Good afternoon, everyone. I'd like to thank you for attending this first webinar that we are organizing alongside with our colleagues from Paul Hastings, Chicago, John Dreamer and Tom Best. And I will start to introduce this with this first webinar. We are going to make a first set of webinars. There will be 4 webinars organized between the 2 law firms, Abreu and Paul Hastings. And I'd like to thank Paul Hastings for joining us in this initiative, which is obviously ours, but theirs too. We choose for this first presentation, for this first webinar, the subject of the prevention of corruption, especially from the perspective on our side of the Portuguese-speaking countries, mainly Portugal, Angola, Mozambique, and Brazil, and from the perspective of the United States, also with relation of what happens in these Portuguese-speaking countries, since we are talking about a phenomenon which is corruption that is also globalized, and therefore we prepare this presentation in order to address all the set of questions ranging from the differences on a legal framework, on culture, on the experience you need to collect from all these countries to draft, to implement and to assess a compliance program that might avoid a criminal case. This webinar, we have the following sequence. John Dreamer will make his presentation, then I'll make my presentation, then Tom Best will do his presentation, and finally my colleague from Abreu, Maria Eduarda Borges, will make her presentation, and then we will have a moment for questions. Please be free to pose any questions on our Q&A, and we'll try to address all the questions and make the final remarks. It will be our colleagues from Paul Hastings to do that. So you are most welcome. Thank you. And now I would like to pass the words to our colleague, John Dreamer.
Thank you. Thank you very much. And thank you to the team at Abreu. Tom, I'm speaking on behalf of Tom and myself. We're very excited about this coordination, this collaboration in terms of being able to talk about important cross-border legal issues in the United States, in Portugal, Portuguese-speaking countries. Again, I'm Jonathan Drimmer. My colleague Tom Best. We're partners at the law firm of Paul Hastings in Washington, D.C. And we're going to start with a discussion about the U.S. Foreign Corrupt Practices Act, which addresses overseas compliance issues and is one of the more aggressively enforced U.S. criminal laws, particularly when we're talking about cross-border issues. Tom, if you want to go to the first slide. So there are 2 different provisions of the FCPA, and whether they apply to any company is going to depend on a couple of factors. The criminal provisions, which is modeled on the OECD convention, effectively prohibits what you would think of as traditional bribery, giving or promising or authorizing anything of value, and what things of value are determined by the value of the recipient as opposed to monetary value, and so they can be tangible or intangible things directly or indirectly, and that there are most of the cases that come up under the FCPA involve a third party. So indirectly is actually more frequently used perhaps than the directly aspect. To any foreign public official, and that isn't just government officials, but it could also be political parties, it could be candidates, it could be international organizations, or private figures, private individuals who are performing government services, and then to improperly influence an official or secure an advantage. So there has to be some kind of effort to obtain an advantage from giving or offering or promising this thing of value directly or indirectly. The civil provisions apply to entities and individuals who work for entities that are listed on a U.S. exchange. So the civil provisions won't apply unless a company is publicly listed in the United States. It's an issuer, quote unquote. However, the civil provisions are incredibly broad under the FCPA. First, they make clear that all company books and records have to accurately reflect underlying transactions, and anything can be a corporate record. Really, any document at all that, if it's falsified, can fall under the civil provision problems. There also has to be a system of internal anti-corruption controls, not just accounting controls, but the way that the SEC, the Securities and Exchange Commission, which oversees the civil provisions of the FCPA, the way they interpret it is there have to be anti-corruption controls, like training, like policies and procedures and things like that. Important to remember, on the civil side, there is no materiality threshold. Any amount can ultimately trigger a problem. That's actually true on the criminal side as well. You don't have to have knowledge of an improper payment. It's effectively a strict liability law, and it applies to all majority-owned subsidiaries or controlled subsidiaries throughout a company's vast span for multinational enterprises. So they're very broad. They have civil and criminal components. They're administered by the Justice Department and the SEC. Next slide, Tom. So one of the reasons this has received such aggressive attention, so much attention and such aggressive enforcement, is anti-corruption efforts are now part of U.S. foreign policy. They were adopted a few years ago into the national security strategy of the United States, as the White House considered corruption to be a fuel for terrorism, a fuel for instability, regional instability. And so it's part of our national security strategy in the United States, and it's also part of our foreign policy. So we've integrated enforcement efforts along with policy efforts, and that is part of the reason we've had so much focus and so much emphasis in the last 10, 15 years on anti-corruption enforcement. As I mentioned before, it applies to any U.S. company, it applies to any U.S. person, regardless of where they might be acting. So a U.S. resident or citizen that is in Brazil or in Portugal, they can be subject to this law. And on the criminal side, any kind of act that touches the U.S. in any way, or the civil side as well. Any act that touches the U.S., and that is interpreted very broadly. So payments in U.S. dollars, for instance, have arguably been argued to be enough to create a U.S. jurisdiction. Emails from someone outside the U.S. to someone outside the U.S. that go through U.S. servers, they found that to be enough of a U.S. tie, ultimately, to create jurisdiction. So again, as part of our foreign policy, with these broad jurisdictional interpretations, it gives prosecutors a lot of authority, a lot of ability to pursue corruption cases, and they've used that authority with a great amount of energy. If you go to the next slide. So what we've seen over the last 15 years is a continued rise of enforcement activity. In 2006, it was fairly modest, and the big jump started in 2007, and it really hasn't stopped since that point. Last year was another very active year for FCPA enforcement in 2019. It was $2.6 billion in fines, which is among the highest that's ever been collected by the United States government from FCPA cases. We had the second most enforcement actions of all time last year, investigations in dozens of countries around the world. And one of the things that we are seeing is increasing numbers of what we call FCPA clusters. And that might be a similar set of facts that exist across an industry, or an investigation into one company that then expands to a number of other prosecutions for companies that are doing business with that particular entity. And so, for instance, we've seen that with the Petrobras and the Lavajato cases. In China with the Princelings, those are a series of hiring cases where companies hired relatives and referrals from government officials. So these kinds of patterns of conduct or activities that often center around a company and its business dealings. There's been a lot of those kinds of things, including within the last year. Over the last year or two, we've also seen a substantial rise in the number of FCPA-related cases like tax evasion and money laundering, as the FCPA unit in the Department of Justice is not just charging for FCPA, but for a variety of other things, in part because there have been challenges to their jurisdiction, their broad jurisdictional interpretations. We've had a number of new guidances and policies that have come out from the Department of Justice to illustrate how it is they're going to approach cases and what their expectations are for companies, which is particularly important. And we'll talk a little bit about compliance in a minute. And from the FCPA side, Tom will talk about that. But that's particularly important because there aren't a lot of judicial decisions. And so the FCPA guidance from the government really is useful in understanding how you can stay out of trouble. And the final point from the last year or so has been the creation by the FBI of an international corruption squad in Miami. So not only have we seen aggressive enforcement, but they're continuing to put effort into task forces and dedicated investigation and enforcement techniques in the US government. And so you see some of the recent cases on the right that have come out of Portugal and Portuguese-speaking countries, and you see some of the numbers that are involved, and they do connect to a number of different industries, a number of different kinds of activities. But the punchline for these slides certainly is, as the picture indicates, it is and continues to be a dog that bites. With that, let me hand it back to our colleagues for the beginning of their presentation.
Thank you, John. Our presentation will address three different subjects. The first subject will be a comparison of the legal framework of corruption-related crimes in some countries of Portuguese-speaking language. The second part of it will be an assessment of what can be done when things, even if you prepare a good compliance program, you have a risk. You have always risk, because one of the things that we will point out is that a compliance program is never concluded. You can have to face criminal proceedings. And in that way, if you have a better compliance program, you can use that compliance program as an instrument for your defense or for your company. The third party will be when everything really goes wrong. I mean, when you do all this, and even so, you have to face criminal proceedings. And my colleague Maria Eduarda Borges will talk about what can be done from the perspective of collaboration. I mean, when you don't have enough means to present a defense, you might opt for cooperation with the authorities. And she will analyze the differences of these collaboration solutions in Portuguese-speaking countries. Can I have the first slide, Lorenzo? Thank you. So when we talk about compliance, things are different whether you talk about anti-money laundering compliance, if you talk about financial compliance, if you talk about corruption compliance. There are a set of principles of good compliance that obviously are applicable to anti-corruption compliance. And the first one is that compliance in general means that you have reached a point where the posture of you within your company, of you within your public service, is no longer to wait for things to go wrong and to have to face criminal proceedings. You have to plan in advance. You have to have a preventive approach in order to avoid to be on that situation. There are steps on the building of a good compliance program that are common to all the areas when you talk about prevention of corruption. The first one is that you have to have a good law assessment. I mean, you have to know very well and deep the law of the jurisdiction you are dealing with. In particular, in Portuguese-speaking countries, we have a very complex framework. We've always had. The evolution of in the recent years has been what was complex multiplicated, so it's even more complex. So we are talking about Roman German country tradition on what concerns law and methodology. So we have a very intricate rules, so you have to know the law. Second thing, you have to know the case law, because one thing is law, the other thing is case law. I will dare to say that in Portugal, for instance, we always had in our criminal codes, even in the code of the last century, we always had corruption crimes, always. And this is not only a perception or a public opinion. We have been facing recently a huge amount of cases. So the number of cases rose with the same law. Obviously that, especially since 2010 in Portugal, Portuguese laws against corruption and on sanctioning and on preventing corruption have been improving, but it's not a perception. There are numbers. So we have many more cases of corruption that are going to submit to trial and are scrutinized on the media, etc. Third stage, the law, the case law, you have to know what you are dealing with. I mean, you have to know who your client is and what she does and how she does it or he does it, what are the proceedings they have implemented on their business, and what his or her culture is really. So you have to, using an expression from money laundering, you have to know your client, you have to know the way he does businesses, you have to know the proceedings they have implemented and the reasons why they have done so. This means that there are situations when you have some proceedings already implemented, and in that case, they must be evaluated and checked, and in order to analyze if they, first of all, comply with the law, if they address correctly what is the case law, and if they really, based on what you already know about your client, if they are enough to prevent the risks of corruption. Knowing that, you can have a compliance program on corruption, but it will never be concluded because people change places, people change companies, and I would dare to say that fighting corruption within a company or within public service, obviously what I referred first is relevant, but we have to know that real people are needed, and that this is also a question of mentality. So you have a cultural question here. There is no organization equal to others. Every organization is an individual. You have to address this as if you are doing a suit with measures for that particular person. So you don't have situations where you can buy a compliance program on prevention of corruption in the internet. That might not work for you, might not, or it's not going to work, I can assure you. So when you draft, after knowing all these steps, when we implement, you have to access and you have to test it. You have to know that the program is enough to face to diminish the risks of corruption your client faces, and you have to know that you can have access to results. You can have a very good compliance program, but if you don't test it, you don't know if it is effective. And this is important. If everything goes wrong, even though you have a very good compliance program, and you have to face a trial or an indictment. And this is the last topic. Obviously, if you have a very good compliance program, and if something goes wrong, and if there is a corruption offense within the organization, you can use your compliance program to defend your client. They say, look, something went wrong. We addressed the risk, and what happened, it was something we could not control. Obviously, that might have civil liability, of course, but from the criminal perspective, this is different from what happens in the United States, as far as I understood from Jonathan's presentation. Here you only have a criminal reaction, which is in the case of legal persons, a fine, and in the case of natural persons, you might have to face imprisonment. You can be inhibited from having access to public tenders, etc., etc. This is all very, very drastic and very serious. Can you change the slide? Okay, thank you. As I already referred, in Portuguese-speaking countries, we are talking about countries with very similar traditions, especially in criminal law. In civil law, in some areas, it is very similar. Angola and Mozambique codes are very similar to the Portuguese civil code. In what regards criminal law, there is, in one hand, they have codes. In case of Angola and Mozambique, they have very recent codes because they had the colonial codes, the Portuguese, the old ancient codes from 19th century until 212 and in 214. So the questions, even when the law was held, the questions that were posed in the other legal regimes were very similar. And here you have some affinities between all these regimes: Angola, Mozambique, Portugal, and Brazil. The first thing that you must identify as similar in all countries is that corruption crimes rely on the payment or on the promise of a bribe intended to a lawful or an unlawful act of a public office. The second similarity is that a public office holder have more severe penalties. So their wrongdoing is in abstract the same, but the fact that one of them has a special duty towards the state, and in these countries, corruption is conceived as a crime against the realization of the justice, so it's against the state. It has a more severe penalty because their wrongdoing is deemed as more drastic and severe. Third one, these crimes are committed, so committed period. It's not an attempt or a matter of conspiracy to commit crime whenever the promise of the offer or the offer are made. If only the promise is made, and obviously is accepted by the public officer holder, the crime has occurred, even if the public officer does not perform the unlawful or the unlawful act. This is very important because some people try to don't understand why this is you can have corruption crimes even if the public officer receives the promise and does nothing. This means that from the side of the ones who make the offer or make the promise, the crime is completely consummated. From the side of the public officer holder, you have two alternatives. One is that he might accept the promise and then changes his mind. And if he accepts the promise and then changes his mind, you have a question of regret, and that is a cause for attenuation of the criminal liability. So in that case, also the public officer holder committed the corruption crime. And but anyway, it's only this question of there is a proposition and there is an acceptance. So it's what is needed to a corruption crime to be committed. Fourth point of where the law is common in all these countries. Even if the bribe is not intended to a particular act, there is a crime with a less severe penalty whenever an undue offer is made or accepted. This is something that it already existed in the Portuguese code of the 19th century. It passed to Angola and Mozambique criminal codes, and it was out of the Portuguese legislation since 1982. It came back in 2010. So this is, some people say this is an influence from the German law, but it's not. This is Portuguese law that was revoked and then came into force again. This is a circumstance where it is irrelevant that you want something to be made by the public officer holder. If you offer something that is undue, and we are going to analyze a case where that happened in Portugal in a concrete case, that will be enough. It's not called strictly corruption in the Portuguese criminal code, but it is sanctioned as a mild form of corruption, so to say. 5, despite the relationship between active and passive corruption, one can occur without the other. This is something that most people don't understand. Most people say there is an old criminal law teacher in Portugal that wrote that active and passive corruption are the two sides of the same coin. That's true, because you are trying to buy someone, and you want, if there it is a classic crime of corruption, not the undue offer or promise receiving. You want something from the people who has power to give that something to you. But you can commit, and I already gave you an example where you offer to the public officer holder a bribe, and he never changes his mind. You offer or you promise, but he rejects the offer, or he hears the promise without altering his state of mind. So he is immune to your bribe. In this case, you commit a crime of active corruption, but the public officer doesn't commit a crime of passive corruption. Finally, it's 6. And my colleague Maria Eduarda will tie this aspect in the final part of the presentation. The penalties for all these crimes and in all these jurisdictions might be lessened if you, having no grounds or very fragile grounds for presenting a defense upon an indictment for corruption, you might think about collaboration with the authorities for the question of reducing the penalties, and also, as Maria Eduarda will address, for reputational reasons. Can we have another slide? The differences. These differences are relevant, especially for because of one thing that Jonathan already referred. We are talking about crimes where there is a lot of interconnection between countries. We are talking about, in the most part of the big cases, of crimes who were committed in the same crime in various jurisdictions. So we have questions of, there are various types of crime from different countries that might be applicable to the same case. This might pose questions, obviously, of nobis in idem. This might pose questions of refusal of cooperation if the countries where the main proceedings are going on ask for the cooperation of the other country, and the other country says that, look, I'm not going to do that because what you want to investigate and the way you want me to investigate violates our constitution. That this has already happened in Portugal in several cases. So the question of the applicable law, because in some circumstances, and as Jonathan referred, national law, Portuguese law might be applicable to facts committed in Angola, for instance, in Mozambique, and the inverse is also true. Differences. In Portugal, in Angola, they have a different framework on this. People who are not public office holders might be held criminally liable for corruption offenses, even by receiving a bribe or its promise. In Portugal, this occurs because since 2015, we have a law governing corruption in the private sector. And since 2015, precisely, a lot of companies in Portugal have been addressing the question of prevention of corruption and the question of avoiding a criminal case, precisely because there was this new law in force since 2015. And in Angola, this occurred through an alteration on the legislation that extended the duties of the public servants to all people who were not public servants. So corruption is no longer in Angola a specific crime. I mean, a crime that requires a special quality, in the case a public officer holder, for the agent of this crime, or for the part that is bribed, which is also the agent of the passive corruption crime. In Mozambique, people who are not public office holders can only be held criminally liable for corruption offenses when they offer or promise a bribe. This is because they don't have either a law on prevention of corruption for the private sector, nor a rule, as in Angola, extending the duties of the public servants to all people. In Portugal and in Angola, when the new criminal code comes into force on June this year, legal persons might be held criminally liable for corruption offenses, all types of them. This means that in the other countries, it's not like that, except from the case, but even so, under different circumstances in Brazil. In Brazil and in Portugal, a special crime is foreseen whenever the bribe is offered or given to a foreign public office holder in order to the latter to harm the functioning of the international trade. This has existed since 2012 in Brazil and since 2015 in Portugal, because this is the same law that passed the prevention of corruption within private sector to Portugal too in 2015. In Portugal, there is a special law governing corruption within the private sector and within international commerce. This is unique in Portugal. Let's see the next slide. So this is a complex framework, I admit. And of course, in the recent year, there has been a lot of cases in these countries. The cases have risen a lot, and I'd like to address a few cases, and only if I'm not going to enter into detail, but I would like to explain why these cases were relevant and which was how they started and which were the fact that they are public. I'm not going to speak, obviously, of the procedural details of the people involved, nothing of that. In Portugal, there are two main cases that I'd like to talk about. The first one is a classic corruption scheme crime that gave rise that originated a big criminal case, which was Hidden Face. It was a corruption case, a major one, that involved people with links to the recycling on public tenders. It was a classical scheme where, according to the public attorney, the bribes were paid to public officers to give a special treatment to the companies who were trying to make some contracts and win public tenders. The Gulfgate is very interesting because it's not a classical corruption case. It is a very interesting case because it was the first case, as far as I know, by what I saw in the news, where the crime of the offering of an undue advantage was was used to start a criminal case. And we are talking about football tickets and travel tickets offered to people in the government. It led to the dismissal of a Secretary of State, at least. And the question was, what was the purpose behind this? If you don't have the purpose, so this is also a corruption crime, but with a less severe consequence. From Angola, I'd like to speak because this is an international case of Sonair case. It was, I don't know how it is right now. It started with an investigation where it was discovered that Sonair, which is a company based in Luanda, used to pay amounts to TAP, a major aviation Portuguese company, for services that were not rendered by TAP. And the question is, it was a scheme, first of all, of money laundering, and TAP, because part of its share capital is public, and the person who was involved in this was considered, according to Portuguese criminal law, a public office holder, received money to help on money laundering, which is obviously an unlawful act, and being the things like they were referred by the prosecutor in the preliminary investigation, we have a classic case of corruption for undue illegitimate fact. In Mozambique, you have the Odebrecht case. It's a very similar to the Face Oculta, where Odebrecht, one of its owners, paid bribes to a minister because of the construction. He wanted to win the public tender for the construction of a major airport. And it was discovered, and obviously the bribes were collected by the state. Brazil car wash, everyone knows this case. This is really an international corruption case because it became worldwide since the Brazilian authorities started to ask for the cooperation of of other countries, namely Portugal. It was also very similar to Face Oculta and to Sonair, because one of the branches of this big case, there are many other things involved. There were many other things involved in car wash. It was precisely the payment of bribes for winning public tenders. Now I'm going to pass for Tom Best. Thank you.
Can everybody see my screen?
Yes.
Excellent. Well, thank you very much, Anarita, and thank you for setting the stage there along with Jonathan. It's an interesting question as let me flip forward here. It's an interesting question as to how all these tie together. And programs are now other Portuguese-speaking countries. What strikes me about the slide that we just had up there, however, was the Odebrecht case and the Lava Jato car wash suite of cases, I think we would call them. All of those originated, of course, not inside the United States, and yet at the same time have thrown off some of the longest running and largest Foreign Corrupt Practices Act investigations that we've ever seen. And so why is that the case? And if we take the Odebrecht case, it's actually a very interesting one in that if you look at the settlement papers that are out there publicly for the world to see, the only jurisdictional links that you see in the U.S. In the U.S. DOJ papers are those that relate to bank accounts being physically located in the United States. And so that case, of course, involved involved the US DOJ component, a very large Brazilian component, and then enforcement actions in some other jurisdictions where money was actually being held. But I think it illustrates that it's really the key enforcement that we've seen in global the last 5 years. These enforcement US Kingdom and in other Western European jurisdictions, in Canada, in Australia, and elsewhere, are beginning to share information very freely and develop the kinds of informal networks that lead to a prosecutor picking up the phone and saying, hey, I've got a piece of evidence here that helps my case, but I really think that you should send me a multilateral, you should send me an MLAT. You should send me a request for legal assistance, because if you send it and you write it in this particular way, I'll be able to send you something that might help you investigate a case that I know is in the press. And I wouldn't be surprised if your supervisor is asking you questions about soon. When you get to the US-Brazilian context in particular, there's been a long-standing history now, over 10 years, of collaboration and training between US DOJ, US SEC, and the Brazilian authorities, where whole delegations of prosecutors and investigators have come up from Brazil to sit with their US counterparts, learn, the US folks learn the Brazilian system and vice versa. In order that they can better work together. And I think, as we've seen, certainly in Odebrecht, in all the suite of Lava Jato cases, that's kicked off an enormous amount of activity. I think if you look at Lava Jato in particular, a number of the cases, I think they're very interesting, have a key Brazilian component, which may be the bulk of the case. So if you look at the amount of criminal penalties assessed, there will be a US component, because maybe the management that oversaw the Brazilian operations of an oil field service company or a construction company might have been sitting in Houston and New York. Maybe or the Nordic countries, or somewhere totally different. And what's ended up happening is that the U.S. has sort of acted as a coordinating clearinghouse for evidence that's created a whole new enforcement dynamic. And I think the Odebrecht case and the Lava Jato suite of cases really shows real good examples of how that dynamic between enforcement authorities has grown over the last 5-10 years, and is really, it could be said, as a product of those cases in a lot of ways. That said, so against that backdrop, we come to 2020 and COVID-19 and the FCPA, and how we're expected to continue our compliance activities, what the enforcement environment's going to be like in this very strange and very new world that is forcing us all, instead of giving this in a room with you in a lovely setting in Lisbon, is making me do this from my home office in suburban Washington. Yeah, looking at this slide, I think it's I like the picture of the snake and the snail. I think it's most apocryphal in that on the one hand, you've got risks out there in an environment where suddenly economic activity has ceased or dramatically been reduced, which tends to be, and I'll talk about a couple of examples in a minute, which tends to be an environment in which underlying frauds, underlying corruption, underlying dishonest economic crimes tend to come to light. That's my snake. Active enforcement agencies out there, but eventually the snail will get to his and they'll come to light. An interesting fact, if you look back to the Hurricane Katrina disaster in the United States in 2005, which came up through the US Gulf of Mexico and heavily hit the city of New Orleans and the state of Louisiana and the US Gulf Coast. The US spent $120 billion US in relief efforts in connection with that disaster inside the United States. It, roughly speaking, that $120 billion resulted in about 1,300 to 1,500 white-collar criminal prosecutions in the United States. The US government alone, just in the last stimulus bill and relief bill passed into law over the last month and a half, just voted $2 trillion worth of spending inside the United States. And countries around the world, all over Western Europe, all over Asia and Southeast Asia, basically every major economic actor in the world has sent upwards of 5 to 10 trillion US dollars out the door. I don't profess to have a crystal ball, but I will make a bet here, a prediction here, that at least some of that money is going to be the subject of fraud and corruption investigations. And what's really interesting and important from a US perspective is that if you're talking about, as Jonathan alluded to, a company that, say, has publicly traded shares in the United States, or may have a significant operation in the US where management sits, that may be managing operations in Angola, say if it's Houston in the oil patch, or Mozambique in the LNG facility, lots of different places. What happens in the United States is only one part of the puzzle now when you talk about fraud and corruption risks. If you're a company with links to the US, what happens in Timbuktu through Portugal or through Guinea-Bissau or through Mozambique or through Macau suddenly may be relevant to your enterprise as a whole. Critical, not just in the US, or catch your these are the pattern that you see in some of the recent Lava Jato cases. In particular, Samsung was a Korean company with Houston headquarters that ended up with a Lava Jato issue and a Korean, US, and Brazilian enforcement action. There is no, and there is not going to be a COVID-19 FCPA FCPA exception. We'll see a little bit of a sort of lull in cases that get brought, but very soon afterwards, probably the typical gestation periods, 12 to 18 months, we will start to see fraud and corruption cases being brought around the world in connection with all the stimulus out there. And some of those, at least some of those, will have an overseas corruption component if you look at it from US eyes. And the US government and our entrepreneurial prosecutors will try to find a way to get a piece of that action. I think that's sure. When you see economic stress, and I can't stress this enough, has happened in Angola back in 2008 in the global financial crisis, and in lots of other, it's happened in Mozambique in connection with the drop in oil and gas prices, lots of examples. When you see economic stress, you see people asking for money. And so we're seeing corruption pressures in customs clearances, public officials seeking to feed their families, if we're talking about sub-Saharan Africa, licensing, security support, all the things that we put up on this slide here are really areas that are under increased stress economically in the developing world and are creating FCPA and corruption risks for companies doing business there. I'll talk very briefly because I want to turn it over to Maria. Talk very briefly about what U.S. government expectations are for dealing with this. There is the U.S. government has come out and said, both in the economic sanctions area and in the anti-corruption area, that if there are issues out there, they want to hear about them. And that's always a double-edged sword should you disclose something to the U.S. government. if you're having issues, whether they are in your operations with respect to corruption or with respect to COVID issues in particular. But the baseline building blocks of what the US guidance that Jonathan mentioned, that goes into a fit for purpose, legally compliant program is not changing. It's not going to change because of this public health issue. The premium on risk assessments, understanding your operations, having a reasoned and thought out basis for why you devoted your compliance resources to the places you did and why you didn't devote as many to places you didn't is a critical building block. There'll be increased focus on governance and how you're managing your subsidiaries and operations remotely, especially when we're all sitting in our home offices at home. How you leverage technology, and if you can be innovative, something where we're going to be forced to do it, the best companies, the companies do the best with compliance, will figure out a way to do this in a way that tells a positive compliance story as opposed to one that kind of puts them on the back burner. It's the basic compliance challenges that we see across the board in normal times are only going to be exacerbated. And I think about third parties. Jonathan mentioned in his piece that the indirectly piece of the FCPA, prohibiting indirect payments to foreign officials, is really has been the more used provision. Well, what does that mean? That means that third parties are your source of risk. And having to change suppliers going bust, suppliers needing additional funds to stay afloat. Anytime there's been a massive change in the supply chain across the world for how we deliver goods, services, and industrial output around the world. Inevitably, that's going to cause anti-corruption and compliance risks. How are we going to deal with these issues internally at companies? We're going to do a lot more like this. We're going to be talking to each other on the phone. We're going to be doing more document-based, more certification-based. We're going to be doing a lot less in person, which I think is a much more ultimately effective way to do it. Let me turn this over now to Maria, Eduardo, so she can get going, and we'll chime in there at the end as well.
Thank you, Tom. Thank you very much. So trying to pick up from Rita's presentation, there will always be cases where it will not be the best option for a company to pursue an active defense in court when things go wrong, be it either because the company's compliance system is not developed enough or is flawed, and therefore the company is criminally liable because of actions, because of crimes related to corruption committed by its leaders or employees. But on the other hand, even if the company has provided itself with a strong compliance plan, there is no case law that supports the consequence of having a strong compliance plan, and therefore not being criminally liable for actions committed by the company's leaders. So whenever a company feels that maybe a strong defense is not really an option, the only alternative will be, and in different degrees, in different levels, considering each jurisdiction from each Portuguese-speaking country, will be to, instead of trying to comply with criminal law from a preemptive perspective, will now be to try and comply with the investigation, to try and get an advantage out of it that will be to, if not eliminate completely, but to mitigate its criminal responsibility, or at an early stage, or if not possible, at least at the phase of sentencing. So if we could move on to the next slide, I'll focus on measures that can be used by companies in Portugal, but also in Angola and in Brazil. Just to give you an example of what measures, what options do companies have when compliance has somehow failed them. So in Portugal, we do have this general admissible mechanism that is called the temporary suspension of the criminal proceedings, that is generally only available for less serious offenses. And what it means is that a defendant at an early stage of the proceedings, let's say during the investigation or until there is an indictment, he might request this temporary suspension, which would generally implicate or it would generally mean him having to follow a set of rules, a set of injunctions, and then the proceedings would be suspended for a 2-year period. And if he were to follow through and comply with these injunctions, following this period, charges would be dropped. Now, what is interesting regarding corruption, and when I'm talking about corruption, what I mean is what we here in Portugal consider active corruption, which is obviously the giving or promising to give something to someone in order to receive an undue advantage, which is what is generally understood as corruption when we're amongst colleagues from other jurisdictions other than the Portuguese. So what is specific to this temporary suspension regarding corruption is not only that this mechanism is generally only available for crimes that are punishable with a sentence of up to 5 years in prison, but that it has a prerequisite that is unique to it, and which has to do with the defendant, in this case our company, would have to have either exposed the entire corruption scheme, or would have at least to have made a significant contribution towards finding out the truth. Okay, so there's no plea bargaining in Portugal, but we do have this sort of, it can be expected a certain quid pro quo, in that if you actively help us uncovering this scheme of corruption, you might get your criminal proceedings will be, or at least may be, suspended, and charges can be dropped if you follow through. But nevertheless, this temporary suspension will always have to consider the company's specific conduct. And by that, I mean that if the company's general conduct was particularly reproachable, this temporary suspension would be off the table. So this is another prerequisite that is not only applicable to corruption, but also generally applicable to other criminal offenses. Regarding Angola, there is no temporary suspension of the proceedings mechanism, so to speak, but it is stated in law number 3 of 2014, so quite recently. Angola has foreseen that the criminal sentence can be significantly reduced, provided that the defendant until the courts, the lower courts have reached a final decision, and until the sentence is passed, if that person or company makes a significant contribution to obtaining vital proofs against the others responsible. So not as good for companies as our solution, which can basically end the proceedings much early on, but still quite attractive from a point of view of cooperating with the authorities. Regarding Brazil, I can say that we've got two very different. It's a completely different framework in what plea bargaining and cooperating with the justice actually means. So there are several laws in the Brazilian jurisdiction that foresee the plea bargaining mechanisms, but the most complete one is number 12/850 from 2013, which basically sets the standard of plea bargaining proceedings for whenever plea bargaining is an option. And we basically have two distinct possibilities that could be construed as plea bargaining in Brazil. We have the first one, which we could call, I suppose, plea bargaining stricto sensu, which involves from the get-go, from the beginning, the idea of making a binding agreement with the authorities, where the company itself can go up to them and try to negotiate to try to get some leverage by exposing something to them. So what they would do in Brazil is basically try to get something to the table and try to get as much leniency as possible, which could go to from not being prosecuted at all to getting to the prosecution agreeing to propose a much reduced sentence to the courts. And this particular option, this particular first option of plea bargaining, so to speak, is also quite distinctive in that it can be used whenever public interest is at stake. So the information that the company would offer to get a positive response from the authorities would not have to be necessarily essential to the investigation. Okay, so and that mostly distinguishes it from when this binding agreement comes afterwards, because and that moves us to option number two, is that when in Brazil a defendant or a person of interest, or even a company that would only have the status of witness, decides to actively participate and aid the investigation, it can have massive benefits from doing so. Things can go from receiving a full pardon or a significant sentence reduction if for instance the company identified other people or companies that either also committed the crime or participated in the crimes at stake. Additionally, another option that would be available if the collaboration was so essential that let's say, for instance, that the prosecution was unaware of the crime, that any crime had been committed, and that the person going forward was not the head of the organization or the mastermind behind this massive case of corruption, and that he was the first to offer collaboration. In this case, the prosecution might blindly agree to not move forward with any charges against that person or company at all. So we do have a quite good range of benefits from cooperating with the investigation and with the prosecution. And another aspect that distinguishes these two options of plea bargaining, so to speak, in Brazil, is that in the first one, the personality or the conduct of the person or company that is procuring this plea is not or may not be necessarily taken into account, as well as the severity of the crime or how approachable it is, which in this second option of voluntary cooperation and aiding the prosecution, this personal aspect would be taken into account. Moving on to my final slide, I would just like to conclude that this final resorts that companies might revert to when facing possible or even very likely criminal charges for corruption is that obviously all stages of the proceedings that I've just described, whether they be in Portugal, Angola, or Brazil, are naturally secretive. So from a reputational perspective, the exact part that this company has taken in committing these crimes, or how its organization has failed in stopping them or making them known to the authorities, would not be disclosed. And I must say that in Portugal, comparing it to Brazil, even if somehow news of this reached the media, the fact that there is no plea bargaining in Portugal, and that these sorts of, whether they be pardon, sentence reductions, or the temporary suspension, which I've mentioned in detail, are always dependent on the conduct and the posture of the company. So even if word reached out that a temporary suspension was granted, society as a whole would know that well, if that was the case, if they let them out easily, so to speak, it was because their guilt was not wasn't so big, or at least it wasn't so big compared to others. So I do think that as a last resort, this collaboration, this compliance with the prosecution, so to speak, this final stage of compliance is an effective measure of the company protecting itself and its reputation and its clients too, and maintaining a good market ability. Thank you.
Thank you, Eduarda. We have no questions on our Q&A, so please feel free to pose any questions you want. But as there are no questions, I would suggest my colleagues to turn again and to make a few remarks, or to say something they they forgot, or to emphasize some ideas they find more relevant. And if you all agree, we have no questions. I will like to start with Jonathan. Jonathan, please.
Yeah, I mean, I think the big thing I would note, and thank you for your presentations, which I found to be really quite interesting, and I learned a great deal. As we look at COVID-19 and what can we realistically expect, and this underscores points that Tom made. You know, the U.S. government right now, they are not generating too many new cases, and the cases they have are moving slowly. But given the history, we are going to see very aggressive and active enforcement in the near term. And anybody who thinks that at this point they can cut corners and maybe get away with things while the government isn't looking, they're going to respond very harshly as soon as they do have the ability to do it. And so I do think we are in a strange timing period, but I would anticipate a very aggressive set of enforcement actions coming down the pike in maybe 6 months, 8 months, somewhere in there.
I'll hop in too. And on the US front, Jonathan made the point early in his presentation that things like the Foreign Corrupt Practices Act, US economic sanctions, a big piece of the US government's law enforcement policy has a foreign policy component to it. I'm sitting in suburban Washington, and there is not a lot in this town that anybody agrees on right now, with one exception maybe, and that is the US and perhaps the West and its economic relationship with China is going to change. We've seen a little bit about this, if you put this in the foreign corruption space and the economic sanctions space already. We've seen it in prosecutions against Chinese technology companies in the corruption space and the export controls and sanction space. I think we're going to see more of those, and it would not surprise me at all if we see, as I talked about, we see the Houston operation of or the New York operation of a Portuguese company doing business in China, subject to sanctions, export controls, corruption investigations, and prosecutions, as just as a result of this, what's going to be a laser focus on new export controls, new trading restrictions, new difficulties, new barriers to trade between the US and China that the US government's going to throw up, and probably the Chinese government's going to do too. We are seeing a sea change in our relationship with that part of the world. And that's backed by political consensus, when really it's the only political consensus that we have in the United States right now.
Thank you, Tom, and John, and Maria Eduarda, for all your presentations. I totally agree with Tom and John when they say that probably this 6-month period with less public scrutiny and less news on the media will necessarily drive us to a period where investigations will be increased again. So I'd just like to point out 2 things. One that emerges from my presentation is that all the cases I referred, they are all finished except for 2 of them. One is the Gulf Gate, is not finished. It finished for some of the defendants. And the other is the Sonar case. So it's a case that has not been subject to trial. So what I said, what came in the news about the facts that the public attorney was investigated at the beginning of the proceedings. Second thing, regarding the presentation of Maria Eduarda, I would just like to point out a slight thing. From my perspective, I obviously agree with everything that she said. It was very well put. But my experience in Portugal with these mechanisms of cooperation of the companies within corruption crimes, sometimes it works, sometimes it does not work. And sometimes it is, and I would like to address this for the Q&A if someone wants to make a question on this. Or sometimes, since we have no guarantee, contrary to what happens in Brazil, where there is a contract between the federal public attorney services, which is ratified by a judge at the Supreme Court. Here in Portugal, you have no such mechanism. In fact, you had a recent discussion on this matter where people concluded that a system like exists in Brazil of contractual plea bargaining will be against the Portuguese constitution, because it would transform the defendant into an object to be attacked by his fellow co-defendants. So it is something that in Portuguese legal tradition, it will be, I think it's difficult, it's very difficult to be implemented. Anyway, the mechanisms that exist and that Eduardo referred, they don't give precise, they don't guarantee the circumstance that once you are subjected to trial, you have a benefit that was by the law, not by the prosecutor. In case your company cooperates, it is something that even criminal lawyers like myself and Eduardo, we have to say this to the clients: look, you can do this, but the outcome, the possibility of solving this at an early stage of the proceedings and with less reputational damage and less money spending, we cannot assure that will occur. Thank you.
Looks like we've got a question.
Oh, two. We have two questions. Katrina Monteiro. How compliance programs are evaluated in Portugal for judicial purposes? It is based in FCPA guidelines, or are there any specific national guidelines for that? There are no guidelines. There is no case law, as Eduardo referred. We have not a solution similar to which is foreseen on the Bribery Act in the UK, where if you are provided with a compliance program, and the law doesn't say that, it doesn't say that it has to be a good quality compliance program. You have to be provided with a compliance program. You can use that according to the Bribery Act to defend yourself. But I think that obviously we are criminal lawyers. We prepare these things. We have some experience on dealing with matters in courts, and I will respond to you that we follow no guidelines. I think that the question is, and I have to do that twice in my career, to argue that, look, I provided my company with, and this company was provided with a good compliance program, a compliance program which was drafted especially for this company, and it was implemented, and it was tested, and it was checked, and it was improved over the time. And people had to learn how to behave, had to learn the new rules. I think this is a question from the criminal law perspective of causation. So if you eliminate the risk of something occurs, in this case is that corruption crimes occur within your company because your company acts are the acts performed by those who are in charge of your company according to Portuguese criminal code. So you can construe a case, I would say, on a lack of causation. Second question. I don't see. No, it's only one. Sorry, it was it was a greeting. Sorry. I've talked a lot, and I thanked everyone at the beginning. I don't know if you have any further questions, if you have any further remarks to make. It was a pleasure. It's been a pleasure to prepare this with you, and I am very glad that this approach had occurred, and these two legal firms started to do these webinars jointly. And I will give the invitation for May 30 will be with the same format and with the same people. We will be addressing AML. So you are all invited. Thank you, Tom. Thank you, Jonathan.
Thank you.
Paul Hastings. Thank you to the attendants. Thank you to Abreu team. Thank you to João, to Lourenço, and everyone, both at Paul Hastings Chicago and Abreu here in Lisbon, that make this project came to life. Thank you. Thank you so much.
Thank you, guys. Talk to everybody soon. Bye-bye.